I'm going to mute myself.
And I trust we will have some more people joining us as time passes. Okay, this meeting of the ASJA SoCal chapter and various other guests from all over the place. The meeting is entitled National Efforts to Kill Freelancer Rights. What do you need to know? And the people here today are people who know what you need to know. And we're very pleased to have them. Some of them have made the trek, or at least the virtual trek from the East Coast. And we're very, very glad to see them as well as the locals. Before we start, I just wanted to mention that now that we've decided to meet every 2 months online, our next meeting will be in July. I'm always looking for a subject matter. Jamie was nice enough to provide this topic, which was a very important one. I'm interested in artificial intelligence and chat GPT, things about which I know nothing. So if anybody knows more than I do, I would be very happy to hear from them. And I'll also introduce Roberta Wax, Robbie Wax, who takes care of being our Zoom maven, and I really appreciate that. This will be posted on the ASJA site, and maybe we've been discussing it on YouTube as well. I think it'll have some information that will be important to all of us. Quickly, I wanted to mention the national ASJA offerings coming up. There's Client Connections, once again, June 5th and 6th, again, online, a chance to talk to everyone from Smithsonian Magazine to Modern Farmer, which seems to me quite a spread, to literary agents, et cetera, et cetera. Also a Zoom virtual conference, which is the closest we'll get right now to a real conference, given the situation in our world these days. Early bird registration is continuing through May 15th. The Zoom conference will take place over a few days, June 13th through 15th. A lot of good stuff, and I do urge you to check it out. I'm just reading Susan's chat here. We're going to have 3 speakers, 2 of whom have testified before Congress on the issues we're going to talk about today. The one speaker that we had hoped would make it, I'll mention her anyway, because she wanted to be here, was Marissa Brown, who is from Southern California and an ASJAer, who has had something to do with writing an amendment to AB 5, which was very important for us writers in California. She was all set to be here until she got that coveted doctor's appointment that space opened up. So we've all been there, so we understand, and we hope it all goes well with her. But among the speakers that we do have here, first of all is Karen Anderson. She's going to speak about the California, there she is waving. She's going to speak about California's AB 5 law. She's the founder and administrator of Freelancers Against AB 5, an all-volunteer group of, this is staggering, 18,500 members, comprised not only of writers, but independent contractors, small business owners, nonprofits, all kinds of people who are affected by this, what seems to me rather misguided law. She's a 3rd-generation Southern Californian, 25-year career as a freelance writer, managing editor, published author, and photographer. She lives in Dana Point. We've had a nice chat, and I like her hat. Next, after Karen speaks, we'll have Debbie Abrams Kaplan, who has helped to found a national organization responding to the New Jersey situation, and the ProAct, which is a national attempt to codify something like AB 5. Debbie is an independent journalist, content marketing writer who focuses on medical and healthcare and supply chain writing. She helped found Fight for Freelancers. How's that for alliteration? See, and in the USA to fight these kinds of freelance busting bills. She's also the ASJA Advocacy Communications Chair, which is an important post that we really need these days. And finally, Kim Kavin. There she is, along with Karen, she addressed Congress talking about the federal implications of the ProAct attempt. She at one time was an editor for newspapers and magazines, decided to become a freelance writer and editor, won lots and lots of national awards, including the ASJA Exceptional Service Award for leadership and heroic efforts on behalf of freelance writers in the fight against AB5 and the ProAct. Very impressive. She helped found, along with Debbie, Fight, what's it called again? Fight for Freelancers, which is a grassroots, all-volunteer, nonpartisan advocacy group which works to eliminate freelance busting language from all legislation and regulation. And she loves dogs. So she knows an awful lot about dogs if you have any dog questions. But right now, we're not here to talk about dogs. We're here to talk about the ProAct and its predecessor, AB5. So I will start with Karen and we will go from there. We're going to, of course, have a lot of questions arising. We will have time in this session to answer those questions. We will go for about somewhere between an hour and 15, hour and 30 minutes. We'll see how it goes, but we'll try to answer everybody's questions. Anyway, Karen Anderson, I welcome you.
Beverly, thank you for that introduction, and thanks for inviting me here to explain to your audience about the horrible law that was passed in 2019, September 2019, called AB5, which is short for Assembly Bill 5. What it did was it codified a California Supreme Court decision where they came up with this ABC test. And it's the most strictest test in the nation for determining classification status. And it's nearly virtually impossible to pass unless you have an exemption. And what AB5 did was it codified that ABC test from that dynamics decision in 2018, and it expanded it to cover all professions and apply to all workers in California, which means that everybody in any business, no matter what business you're in, whether you're presumed to be an employee unless you have an exemption or you can pass the ABC test on your own. And so that created a huge amount of chaos when people started losing their livelihoods overnight, right after the bill was signed, before it even went into effect on January 20th. And one of the groups that was impacted negatively were journalists and writers. And the author of the bill, Lorena Gonzalez, imposed a 35 yearly cap on submissions for freelance writers, which meant that, I mean, there wasn't really a definition of what constitutes the submission. Could it be a single blog post? Or it could be a book, or it could be a 5,000 word article. There was no definition of what a submission would be. So somebody like me who does a lot of travel writing and for HarperCollins imprints and Fodor's travel, is that I could run through that 35 limit within a month and be knocked out of being able to write for Fodor's for the rest of the year. So a lot of writers started losing their clients overnight. And what we saw was Vox Media. I think they laid off 200 writers and editors almost immediately. And people like columnists, weekly columnists, started getting dumped from their clients, their newspapers, and cartoonists and all sorts of creative professionals. The law impacts hundreds and hundreds and hundreds of categories of professions, and it still does to this day. It's not a thing of the past. It hasn't been repealed. It has negatively harmed so many legitimate independent contractors who are licensed professionals, six-figure earners, consultants, theater groups, community theaters have been decimated by AB5. Transcriptionists are virtually extinct in California because of AB5. In fact, if the freelance transcriptionists in California is the only state that does not allow it for the freelance transcription profession. And it's just been devastating to women and seniors because that's what comprises that sector. Nonprofits, independent healthcare workers. We had stories coming in from forensic nurses about how it was affecting their ability to treat rape victims. It affected translators and interpreters, sign language interpreters, musicians. All of a sudden, if you had a little bar band in your neighborhood bar, you had to make everybody in your band an employee, including somebody who would sit in with you. So musicians immediately were out of work. They weren't able to do that kind of thing. Festivals started closing, community theaters, children's theaters, opera companies, everybody was starting to shutter their businesses long before the COVID lockdowns. And this law, because it was so onerous and so destructive, affected a vast swath of professions, a vast swath of demographics and incomes, and the spectrum of political affiliations. So we had people coming into my group sharing hundreds and hundreds and hundreds of stories coming into my group of devastation and lost livelihoods. And these were people, they were Democrats, independents, non-party preferences, Republicans, and everybody in between. It was an equal opportunity destroyer. And so everybody, it was like it was like the Titanic and people were swimming for the nearest lifeboats. Yes?
Yeah, I wanted you to answer, because this may be arising in people's minds. What was the logic behind this in the first place? And what exactly is the AB5 test? What did you have to prove?
ABC test is,
excuse me.
the ABC test has 3 prongs that you have to meet in order to be allowed to have an independent contracting relationship. And the onus is on the hiring entity to prove that your contracting relationship can pass this ABC test. The first is that you can't have control and direction over your independent contractor. The second is that you have to be outside the usual course of business of the hiring entity. And that's the B prong, which is so problematic for writers, because writers and newspapers and publishers are all in the same business. So you would be forced to be made an employee unless you had an exemption. And the third is that you had to be customarily engaged in the profession that you're in. So you couldn't be, you couldn't just be a one-timer on something that you've never been engaged in before. So it's very onerous and very hard to pass. We had in California and still have a multi-factor test called Borrello, which is more flexible and it allows for more flexibility and freedom for independent contracting. And you still, even if you pass the ABC test or get an exemption from the ABC test of AB5, you still have to pass the Borrello standard, which is none too easy either. So it's very, very hard for a publishing company at that time to want to contract with writers. Now, a little later on, 9 months later, after all of this, the pandemic kind of obscured the damage because everybody was losing jobs right, left, and center. On September 4th of 2020, they passed an urgency clause that granted exemptions for some professions, and one of those was writers. But there's still restrictions on writers, and we're still hearing that, in fact, there's an ad agency up in Portland that is getting audited for hiring independent contractor writers, and writers who work for this agency even maybe once for $600 are getting notices from the EDD wanting to talk to them and find out what their contracting relationships were, because they're going after Adobe, which is based in San Jose. So there is a chilling effect still on writers, although most writers are able now because of the exemption, so long as they meet all the 7 criteria of their exemption, because it's a partial exemption, they're able to work. But however, there is a chilling effect. Some companies are advised by employment law attorneys just to stay away from independent contractors altogether. And I'm sure Adobe and that ad agency is going to be eliminating all their independent contracting relationships now that they're getting audited, even though writers have an exemption.
And what was the original impetus for this? Who wanted what in creating the system?
The bill was sponsored by the California Labor Federation, which is a coalition of 1,200 unions in California. So it was union sponsored. They really wanted to go after Uber and Lyft and trucking. Those were their main targets, but really they wanted to control that entire independent workforce. So we're not just dolphins in the tuna net. It's by design. They want to make as many people employees as possible for the purposes of unionizing people, and also for payroll tax revenue and that kind of thing, and just to squelch the trajectory of the independent contracting workforce. And so it's just been a complete mess in California. It's still a mess. The audits and fines on people who hire independent contractors, if you're found to be misclassifying somebody, can put you out of business. It's in the hundreds of thousands. And they're not just auditing larger companies, they're auditing. In my group, people are coming in and telling me they're single people, like wedding photographers or a dog walking service owned by a single person, or a referee and umpire platform owned by a single person, or a music store owned by a single person, or a florist, or an architectural designer, are getting audited for hiring independent contractors. And even if they pass even if they pass their audit, it is such a traumatic experience for these people and it costs so much to defend yourself, that some of these people just abandoned their businesses altogether, like the videography platform, family-owned videography platform company that got audited. It was just the horror stories. The audit stories are really the rude awakening for me as to how it affects small businesses. So once but the problem is that people don't want to be employed. People who are self-employed like myself, we don't want to be converted into employees. We make more money setting our own rates and picking and choosing our own clients and deducting our expenses. That's a huge one for me. And being able to expand our skill sets and create opportunities for ourselves that would never be available in a 9-to-5 W-2 environment. So it's just been devastating, and it continues to wreak havoc across the vast swath of professions, and hundreds of thousands of independent contractors in California have been adversely affected by AB 5, and it's a fact.
Can I throw out a question, Karen?
Sure.
And I don't know if you know the answer. It's okay if you don't, but we're watching the Writers Guild of America strike against the TV and film studios. Why is it that particular group of writers is happily unionized? Because the rest of us don't really want to be. Do you know what, are they all W-2 when they go on to a project? Is it something in the nature of that business, that end of the business? I mean, it's such a disparity from what the rest of us do in terms of them being unionized and the rest of us not wanting to be.
In California, it's illegal to be an independent contractor writer in the TV, movies, film, broadcast, and radio. You cannot. And it's because the union presence in that industry is very strong. So the writer's strike, anybody who tells you that, oh, they want to make us independent contractors, they're not allowed to do that. The exemption in AB 5 does not extend to that segment of writers. And the unions in California are very, very powerful. Also, another like a print journalist has an exemption, but if you're a videography journalist and you want to, if you shoot some kind of, you know, breaking news story on your iPhone and you want to sell that as an independent contractor to a TV station, you're not allowed to do that. The exemption does not extend to videography journalism. So there are a lot of ASJA had a lawsuit, and that I thought it was very helpful to get that cap lifted, because I think she realized, the author, that it was unconstitutional, that cap on submissions, and it really was. It was very arbitrary. She didn't know the first thing about the writing profession. Writers had to educate her about how we operate in this new digital world, and she's thinking of writers in cubicles and telling us that these aren't real jobs, our independent contracting, we get exploited, and we're telling her, no, these are our careers, and we're professional service. We offer our professional services to clients, and this is our business. And it took a lot of negotiating for her to wrap her head around the writing profession, I think. But writers were very vocal.
Actually, I'm really tempted to add something. Jamie brought up something very interesting about the film industry, because I worked in low budget film industry, and there definitely are people who are writing who are not part of the union, but the pay is terrible. I mean, these are people just starting out. In some cases, there are union writers who are kind of freelancing under different names so that they can just make some pittance, but it's going to be a pittance to be making low budget, cheapy movies for almost no money and no long-term benefits. So, you know, the writers need what they're getting, although they seem to be getting screwed at the moment too, as the industry is changing.
Well, it just goes to show that having a W-2 job isn't all it's cracked up to be. And there's, you know, and as far as these companies hiring a writer full time so that you can have benefits and that kind of thing. I mean, AB5 doesn't require that the hiring entity hire you full time. You know, in fact, most people just got dumped by their clients when AB5 went into effect. They couldn't use them anymore. You know, they just terminated their contracts and assignments and everything. So, you know, it was very devastating for a lot of people. There were some prominent columnists in prominent papers like the San Francisco Chronicle, who when they reached their limit on their weekly column and was told they were let go by the paper, and you know, editorial cartoonists and all the people all the professions that are in the professional service category of exemptions under AB5. And it's that the law itself is so convoluted. I mean, the ABC test is what, 75 words, but the law itself is like 5,000 words with all of this language that even attorneys don't understand, and courts are going to have to interpret, and auditors don't understand even. We've had audit stories. Dog walkers are supposed to be exempt, for example, and somebody came into my group yesterday and said, I'm getting audited, and the auditor doesn't even know about the dog walker's exemption, and he's a dog walking service. And so they have to appeal that decision, and it's just AB5 is a lot of people in California don't understand it. They don't understand how it applies to them, or if it does apply to them. But once you get audited, or once you get terminated from your clients, then you learn about AB5 really quickly. And it's always hanging over our heads. Even if we have an exemption, it hangs over our heads because there's a chilling effect when they go after independent contractors.
Kim, did you have something that you wanted to add right now?
Just to Jamie's question, I've also heard it explained about the Hollywood stuff, that when they're making those big budget movies with, like, you watch the credits, 80,000 people working on the film or whatever it is, there's an issue with intellectual property. So they make everybody a W-2 of the film so that the people who own the film don't have to have fights endlessly in court if it's like the next Star Wars and makes $1 gazillion and everybody comes in and says, oh, I didn't get paid for whatever. So my understanding is the reason they are unionizing also has to do with that, but I've never worked on a film like that. So I don't know, it's just a thing that gets tossed around as to why those particular types of writers, that's very different from, we contribute one column a month to a magazine. It's pretty clear who owns that IP and nobody's going to fight about that. So it's a different thing.
Should we, Karen, are you pretty much finished with the California story, or is there something more you want to add? Because
Oh, well, that's just the tip of the iceberg, Wood. I just gave you the cliff notes. There's just so many horror stories, and in my group I've archived every single one of them. And when you go into my group and you view the archives of stories categorized by professions, from everybody to like lactation consultants and forensic nurses and fly fishing guides and lighting directors and film producers and opera singers and professional Santa Clauses and everybody under the sun, when you read the stories, music therapists, speech language pathologists, when you read these stories, you're just horrified and you wonder, how can the state of California do this to Californians? And people were in life-threatening situations when they got their careers and livelihoods taken away from them overnight. And some people had to flee the state to protect their family, their sick family members, so that they could continue working at home as an independent contractor. And it's been a dumpster fire, and it continues to be a dumpster fire.
if there aren't any immediate questions, I'm going to turn to Debbie and the national scene, or at least the New Jersey and then the national scene.
Yeah, I will start with the state scene. In November 2019, before AB 5 took effect, but after it was passed or signed into law, a bill was introduced into a lame duck session in New Jersey, something that we probably would not have noticed had a number of us not seen what was happening in California. And it turns out what we later found was that there was a national plan by the unions to move it through the more liberal states, those states that were going to be more open to these types of laws, and start doing it state by state. So Fight for Freelancers started with a handful of writers, most of whom are ASJA members. Jen Singer coined the phrase Fight for Freelancers. Her son, who is a graphic designer who was in college, designed the logo. And she started a Facebook page, and it sort of took off. So the group was open to everybody, and we got people from a number of different professions. Of course, it was heavily writers because that's who our main circles of contact were. But it grew to more than 2,000 in the course of the next number of months. In November, a group of us went to testify at the Senate Labor Committee hearing, where the bill was being read, I think for the second time. I think they have to do 2 readings. So we all showed up. We packed the courtroom. I think most of us had no idea what we were doing. We are not a group. We like to say we're a group of ad hoc advocates, self-funded, grassroots, of all political persuasions. So we went to the courthouse dressed in real clothes, some of us with makeup on. We had alerted the press because we're very good at getting information out. State House, yes, not the courthouse. Thank you, Kim. We're very good at getting press. So some of us had some talking points ready, and we got some media there. The legislators were a bit shocked to see how crowded it was for a meeting that normally had very few people. There was a trucking contingent there. They had gone before, and everything got pushed through because they don't speak English. And sad to say, in New Jersey, they're kind of after the truckers to the owner operators. But they had not made it very far, but in the past, because they didn't have sort of that power of the pen that writers have. So they let us all speak. We weren't sure if they would. We all had our little speeches prepared. Kim, not shockingly, made it onto the news because she was very very spirited and was able, and fortunately she went first so she could handle some of those questions that the rest of us were terrified would get lobbed at us. They had changed the bill that morning. You know, they can make amendments. They had changed the ABC test, which we didn't really know much about actually what the ABC test was. But they had changed it from the California version to the broader version, which is a change in the B prong. So instead of just the same line of work as a client, it's the same line of work, or you step foot in their office and work in their office at some point. So that made it a little better, but still not good. But it wasn't just the writers. There was a baker there, there was a musician there, corporate rev people, the transcription company was there, VIP Kids, which is an online tutoring company, they were there. And there were some other lawyer types there watching as well. There were 2 people testifying in favor of the bill, both union related. And the rest of us, I don't know, 30 some, 40 some, were testifying against it. So we knew we were going to lose because Steve Sweeney, the Senate president, made that pretty clear. It was a Democratic majority committee. So it did pass through the committee, which we knew it would. Kim got summoned to Steve Sweeney's office after and got dressed down. She could hold herself well enough. The rest of us might have had a more difficult time. But in any case, this began a lobbying effort on our part. We were trying to figure out, what do we do? How do we do this? Jen Miller got an op-ed into the Philadelphia Inquirer, which got a lot of attention. It really kicked things off. Eventually, and I don't remember how far after, Kim got an op-ed into the Washington Post going after Steve Sweeney. That was received really well by Steve Sweeney's office. He was thrilled about that. We could almost hear the shouting from Trenton. The main thing I wanted to say is, none of us knew what we were doing, but we know how to write letters. We know how to make phone calls. We knew how to rally people. And it was a lot of this little networking and advocating and calling the legislative offices and talking to the aides. And what we learned is you make friends with the aides. The aides really are the keys to the legislators. And so Kim especially was excellent at staying in touch with the aides, getting information from them, feeding them information. We were all calling our legislators. We started a MailChimp account. We were sending out press releases, very grassroots effort. But we ended up meeting with the assembly, the head of the assembly. So basically the counterpart for the Senate. A 10-minute meeting turned into an hour. Kim and Jen and I sat there and went through our reasoning. We had our little speeches down. We had the order down. You learn as you go. And I just want to stress, none of us knew what we were doing. And they killed the bill. They didn't kill it. They didn't bring it to a vote, I think, because they realized they didn't have enough votes for it, because we had made enough noise, and there was enough noise finally coming from others, the business community, and they realized they couldn't shove it through. They did reintroduce it the next session. So January, the session ends. We had a big party in our houses because that's what we did. And then it was reintroduced only by the Senate. The Assembly did not reintroduce it because they realized, the head of the Assembly realized it had problems. At some point while we were advocating for this, we were told, instead of going to our legislators, we needed to go to the AFL-CIO head in New Jersey and negotiate it with them, because they had written the bill. And that was a little bit beyond belief, but and I might not have believed it myself had I not had that phone call with Kim. We had to do a phone call because the AFL-CIO did not know how to use Zoom in, I don't know, January or February 2020. They literally like, we don't know how to use Zoom. We're like, dude, your wife just had a baby. You're not even old. Like, come on, you should. No, anyway, we had a really quick phone call because this is going to come as a shock to everybody, but they didn't want to change anything in the bill. And I know, and they didn't really care about us, because really what they cared about is the construction workers and maybe the Uber drivers. So we were all going to be just roadkill. So we end up shifting our fight, we're still watching it in New Jersey. And one more quick thing, and then I'll move to Kim or questions or whatever. But things kind of died down until I think it was last winter. There are 2 bills were introduced providing basically exemptions from the ABC test to golf caddies and to real estate agents. So Kim and I went to Trenton because like we had nothing better to do than go spend a day driving to Trenton, packing ourselves in the middle of COVID into a room with a bunch of white men to go read our little speeches and tell them how, even though we believe independent contractors should have the right to be independent contractors, you can't build a bill by exemption. And the whole reason they wanted to do it by exemption is because that's the only way it's going to get done. So I went after my local legislator who introduced the bill. He cornered us in the hallway to say, oh, you cute little ladies, how dare you misunderstand. And really, you just have to lobby the legislators for your own exemption. And that's how this came. The big golf courses came and lobbied us. And that's how we got the exemption. And so Kim had called her BFF at the local news station, who came and recorded us telling our story, and then got him on camera literally saying the same thing. I could not believe he actually said on camera, they lobbied us so they got a bill. He literally said that. So we pass a sign every once in a while on the highway and I flip them off. I probably shouldn't be saying that on a recording, but and then that ended up for some reason not getting signed by the governor, but the realtors got their exemption. And the idea of going exemption by exemption instead of passing, when we see in California, there's 600 professions that Karen has documented. The idea of doing it exemption by exemption and having to lobby one by one is ridiculous. We just don't want a bill. We don't want a bill that's going to kill independent contractors, period. That is our story.
Okay, well, now the very forceful and slightly terrifying Kim Kavin.
I only yelled at that one senator because he kept telling us that outlawing our careers would protect us. So he had it coming. It wasn't my fault. I was very polite until he started saying that to me. And then I accidentally yelled on TV and we became a little famous. That's what happened. So yeah.
Oh.
Yeah. So all of that that you just listened to happened between 2000. When was AB5 first introduced, Karen? Summer of 2018, somewhere around then?
No, it was first introduced it passed the assembly in May of 2019. So it really didn't take very long for it to be crafted.
So everything that you just listened to happened in the course of about a year between California's law getting passed, becoming law, New Jersey trying to copy it, California having to pass emergency exemptions, writers having to fight for emergency exemptions, 12 months or so. All of that happened that fast. The plan was for them to then, they had already introduced a copycat version in New York. There was a guy, a lawmaker in Illinois, Will Guzzardi, talking about introducing it in Illinois. The plan was to roll it out in a bunch of different blue states. What happened was they saw the horrifying results in California. They saw the outcry in New Jersey, specifically the fact that writers were rising up and shedding daylight on what was going on. That scared the patooties off these guys. So writers were very integral in stopping it in New Jersey. New York then backed off. Illinois never introduced the bill. And we thought, okay, maybe that's the end of that. Maybe they learned their lesson and problem solved. What happened then is we had the election where the Democrats got control in Washington of the House, the Senate, and the White House all at once. And all of a sudden, the unions said, well, forget about the blue states. Let's just go for the whole country with this thing. It happened overnight, just like that. So literally, we got word that the New Jersey bill was dead. And within 24 hours, there was an article on The Intercept that said, hey, there's a federal version. It's called the Protecting the Right to Organize Act. It happened that fast. And that was all right before the pandemic. So what they're trying to do at the federal level, President Biden stated it explicitly when he ran for president. If you had gone to his website, joebiden.com, where he lays out all his policy positions, he said California paved the way for the country with this ABC test. And as president, he would make this ABC test the basis for all federal labor, employment, and tax law. The plan is to copy what happened in California nationwide. It's not debatable. It's not in our imaginations. We're not crazy people. This is the plan. So the Protecting the Right to Organize Act, just like they had step 1 in the states, they were going to do California, step 2, New Jersey, step 3, New York. At the federal level, it was going to be step 1, labor law. That's the ProAct. Then step 2, employment law. Step 3, tax law. So they tried to get the ProAct through Congress. They passed it through the House of Representatives twice, and they came within 3 votes of passing it through the United States Senate. We were integral in helping to convince, and so was Karen Anderson and her group. We were integral in helping to convince those 3 senators to block that bill so that the Protecting the Right to Organize Act did not go through with that ABC test in it. Whatever you want to say about the rest of that bill, it's one of those big, fat, long bills with 85 million things in it. But that ABC test was at the top of page 1 and they wouldn't take it off. And so we screamed and yelled until the bill died. So we were very grateful to, it was Senator Warner, who's a Democrat from Virginia, Senator Mark Kelly, who is a Democrat in Arizona, and Senator Kirsten Sinema, who at the time was a Democrat in Arizona. She's now an independent senator in Arizona. Those were the 3 who saved our bacon. Very grateful to them. Now, this agitated the White House, right? They wanted this to be part of a big rollout for all labor, employment, and tax law, and it got blocked for labor law. Then we had another election, and now you have the Republicans in the House and the Democrats control the Senate. So there is no way that bill can get through. The Republicans will never pass it. So for now, the ProAct is dead on arrival in the House of Representatives, which is good for us as long as that ABC test is in it. But that does not mean that our opponents who want to do away with freelancing are going to stop. So they have now turned their attention from the legislative branch of the federal government to the executive branch of the federal government, which they still control. What President Biden has been doing now has been trying to go through agencies that are under the umbrella of the White House to try and shove this kind of thing through with regulatory changes. They don't have to be voted on by Congress. Agencies can just issue a new rule and say, this is how the world works now. And after that happens, everybody ends up in the courts and going to the Supreme Court. So that is what's taking place today, right now. The National Labor Relations Board is working on changing its independent contractor definition for the purposes of labor law regulations. The United States Labor Department has already put forward a proposed new definition of an independent contractor for the purposes of employment law. And just in the past couple of weeks, we have heard the Federal Trade Commission start talking about how they're going to change their definition under antitrust law. So this is a whole of executive branch approach now to trying to do what they couldn't do through Congress. The most immediate problem, did somebody have a question? I heard.
Yeah,
somebody.
I did. What was in those redefinitions?
So the National Labor Relations Board requested amicus briefs, which means everybody files a position paper, basically, or a white paper, as we would probably call it in ASJA, but it's like a legal thing. I think it's Latin for like friend of the court brief or something like that. And they argue about whether you pronounce it amicus or amicus, tomato, tomato, I don't know, but some lawyers told me it's amicus, so I'm saying amicus. But we filed one. That was the first. We had to learn how to write an amicus brief, which we couldn't even pronounce. That was super fun times. And we have yet to see, that case is called the Atlanta Opera case, and we have yet to see a ruling from the National Labor Relations Board on that, so we don't know which way they're going to go. We know who they're run by, so we know the people in charge of that agency under this administration are union organizers. They do not want, they're on Team California about this. So they're going to try to find a way to do something that will hurt us. We just don't know how with them. The story is different with the US Labor Department, which did put out a written proposed rule for what you have to do to be a legitimate independent contractor. That proposed rule is 184 pages long. And I highly recommend reading it if you have insomnia, because you are going to fall asleep or want to stick your head in the oven and turn on the gas. It's horrible. But what they are proposing is that, so what happened at the end of the last administration is the labor secretary put a new rule in place to protect us, people like us, specifically against AB5. He wrote, we see what's happening in California. We don't want it happening at the federal level through regulations at the US Labor Department. We're going to put this rule in place as guardrails so that this nonsense cannot spread through the administrative branch. What the current administration is trying to do is throw that rule away. They already tried once. The federal courts said what they were doing is illegal. Now they're trying again. They've put through this 184-page thing that has a 6-factor test. So ABC is a 3-factor test, and the current proposal at US Labor Department is a 6-factor test. But if you look at it, they're trying to do the same thing. So like you heard Karen explain earlier, the B prong of the ABC test, that's the buzzsaw that catches a lot of us. If you're in the same line of business as the person paying you, you are no longer legally allowed to earn income as a freelancer. The 6-factor USDOL test has language that says if you are doing work that is integral to the business of the company paying you, you can no longer be considered a freelancer. So you can see what they did there. It's like a kid who went to Wikipedia to try to write a term paper. They changed a couple of words, but it's still the same. They're copying and pasting is what they're doing. And they're burying it in endless amounts of nonsense. And I see Debbie is posting something. She's right. Technically, so they also have a line in this proposal that says, we may also consider other factors to determine, on top of the 6 factors, we may consider other factors to determine if you're a legitimate independent contractor. But they don't say what else they might consider. So like the former head of the Wage and Hour Division testified in Congress when we were there last month, her testimony literally said they might as well be offering to use a Ouija board at this point. We know they don't like us. We know they don't want us to exist, and they're trying to do that. So likely that the next thing that will happen, most likely, is the US Labor Department currently is without a secretary. Labor Secretary Marty Walsh has left to go run the National Hockey League Players Union. They're trying to install in that job a woman named Julie Sue, who, used to be California's Labor Secretary enforcing Assembly Bill 5. You could not ask for a better. If you wrote it this way, they would send it back and tell you it's too on the nose, it's ridiculous, but this is what's actually happening. So there's a big fight going on now trying to block Julie Sue from getting into that job. If that happens, there may or may not be a delay. We were expecting this new independent contractor rule, the final version of it, to come down this month. Depending on what happens with her, it might be delayed into the summer. We'll see. But what will happen when that new rule drops? A number of things are going to happen almost overnight. The first thing that's going to happen is U.S. Representative Kevin Kiley, who chaired the committee where we testified, he has been a champion for people like us. He's out of California. He fought at the state level in California, and now he's in Congress and he's fighting for us at the federal level. He's immediately going to introduce a bill in Congress to use something called the Congressional Review Act, which is where Congress can undo bad things that regulatory agencies in the executive branch do. So they're going to try to stop it that way. The other thing that's going to happen is immediately the Department of Labor at the federal level is going to get sued by, I don't even know how many people are going to sue them, but a lot of people are going to sue them. Just reading all the public comments that were filed, the law firms that filed public comments, it's going to be a heyday. They're going to make a lot of money in the Washington legal swamps. They're going to have a good time. But that should all tie up this new independent contractor definition in the Labor Department. potentially up until the next election cycle, at which point we will all see who wins what in Washington and try to figure out what happens next. That's where things stand. So are you sufficiently frightened? Because this is why we went to Congress. And I know when we posted it on the ASJA website, politics are gross. We all agree that politics are gross. And what's happening now is the Republicans have figured out that this is an issue they can beat up the Democrats with. So the hearing that we went to testify in, they named it, we didn't have a say. They named it examining Biden's war on independent contractors. So I think that's the kind of language we're going to see coming into the upcoming presidential campaign. I think we're already hearing candidates. I don't think he's a declared candidate yet, but like Senator Tim Scott's going to run. He's been talking about this stuff. There's others who are going to run who've been talking about this stuff. They have figured out that this is a bad policy position for the other side. So I think there's going to end up being some politics mixed in. And I want to just reassure everybody who's watching here, all of us are doing our level best not to let politics get in the way of this. Like you heard Karen say, her group on Facebook is everybody. So is Fight for Freelancers. We have people who have voted for everybody from Bernie Sanders to Donald Trump in our group. We all just agree that the right to choose freelancing needs to be protected. And whatever lawmakers will help us with that, either in public, behind the scenes, Republican, Democrat, we don't care. We want the problem fixed. And that's what we're trying to do.
Bravo. Are there, yes, very good, all of you. Are there some specific questions that should get asked right now?
Are you asking us what people should be doing right now?
Well, I wasn't, but I can. What should people be doing right now?
So what can you be doing? You need to be talking to your lawmakers. Everybody has one member of the House of Representatives and 2 senators who represent you. Wherever you live in America, you have one member of the House of Representatives and 2 senators, and you can go to the federal government's website and type in your zip code. It will tell you who they are. It will give you their phone number, their email address. It'll say, click here to send an email, and you just have to fill in the form and it'll go right to them. You need to be telling them that you want the attacks on independent contractors to stop. It's just that simple. Honestly, if you are a Democrat talking to a Democrat that is your elected official, that is even better. That is more helpful because those are the folks we need to get their attention. That's how we stopped the bill in New Jersey. We had help from Republicans, but it was moderate Democrats behind the scenes who helped us end that nightmare at the state level in New Jersey. So, and we have seen people like the moderates, like Senator Warner in Virginia, Senator Kelly in Arizona. These are moderates that are Democrats who are standing up and saying, no, this is a bridge too far. So call your representatives, tell them who you are, tell them what you do for a living, and tell them you want to remain an independent contractor. And if you want to sound smart about it, you can come to the Fight for Freelancers USA Facebook group. We have a bunch of really cool templates that Debbie put together because she's a goddess, and it'll tell you things that you can say. We've got some cool stats and data in there, so you don't have to look anything up. We built a website, fightforfreelancersusa.com. It's got a whole section with data and studies if you want to pull things. It's got videos you can tweet out. It's got anything we could think to make, we have made and put there, and we're always open to new ideas. So the goal is not to be partisan. It's not to be political. It's not to be anti-union. It's not any of that. The goal is to protect the choice of self-employment. This is what I said to Congress. Since the day this nation was founded, we have all had a right to hang out a shingle and go into business for ourselves and offer our services for sale. That's all we're talking about here. There are now people trying to take that right away, and we want that right protected. That's what we want. And we hope that everyone will join in and help us.
Can I add one little thing to that? We're all writers here. We have the power of the pen and the power of print media. And so you can write a letter to the editor, gets a lot of views, just a letter to the editor. I personally have written probably 15 op-eds about AB5 and some of the national efforts against independent contracting. I've gotten them published in major publications like the Orange County Register. And so as writers, you can really rise up and talk about how devastating this law has been in California and continues to be, and that you don't want to see it spreading nationwide.
Can I throw something out there?
Please.
Because a lot of us write about different industries. And what I've done is I've linked this issue to the industry I cover and let them know that this is a threat to their livelihood. In my case, it's design, building, remodeling. So I interviewed the one of the executives at Associated Building Contractors, which is one of the first groups that's going to be bringing a lawsuit if this goes through. So we really want to, if you cover an industry, make it relevant, pitch that too. It's not just, you know, us media elite types who count. It's the folks who have, you know, small businesses, you know, in your groups, that the ones who aren't part of that, who aren't on social media as much and aren't reading as much, they should be hearing it within their professional circles, within their business circles too. And one of the ways that I put it is, especially, you know, you're talking about a lot of women who prefer this format because, you know, it might be age related, it might be caregiving related, might be childcare related. And that's something that, you know, each group says they are pro women. Well, make it real. You're pro-choice when it comes to our wombs, but not our wallets and our livelihoods. That doesn't make sense. So make it specific to the businesses you cover and really kind of talk about the 50+ people, the disabled community, the women community, how many businesses that are minority owned are part of this, because, you know, that's the biggest small business start group, are minorities. And that's the one that the folks who are pushing this are most at risk of losing.
I like that line about pro-choice, about our wombs, but not our wallets. I've been saying you're pro-choice when I'm in the doctor's office, but you're not pro-choice when I'm in the home office. Same
That's
exact.
a good one too.
I
like
want
that.
all the choices. I want all the choices available to me.
Whatever, improvise in your own style is what I always say.
I can also state that a lot of people don't believe that AB5 is causing the damage and destruction that it's caused in California. A lot of people will say, oh, there's all these exemptions. It only applies to Uber and Lyft, and they need to be, you know, they're being exploited, and truckers are, you know, and it's just simply not true. There's so many professions that have fallen through the cracks that don't have the lobbying power or representation. Like Kim was saying, you can't go exemption by exemption by exemption. It's just scorched earth to just burn down the entire village and then pick through the rubble and figure out who can get an exemption and who can't, and who has the better lobbyists and the loudest voices to get an audience. It's just so destructive and restrictive. And so when you get into a discussion with somebody, say, well, what are we going to do about all those poor exploited workers? Well, there's laws on the books already. And AB5, as we've seen in California, is not the answer. Neither is the ABC test, because it's just catches too many dolphins in the tuna net.
Well, with all the exemptions in California, so for instance, I am in radio reporting. Writers were exempted, but not journalists. So I, as a journalist, am not an exemption. And so I used to be able to freelance for 5 different outlets and resell things to each. And now I can freelance to 1, and the rates did not change. And so, and that one outlet, their attorneys have decided that, well, we fall under the music industry audio producer exemption because you're an audio producer, but I'm not a music industry audio. So the exemptions have just introduced all of this confusion, and these companies are like, screw it, we don't want anything to do with this. So it's yeah, it's accomplished what they wanted to accomplish.
Right. I mean, some professions, like they say there's, 100 professions are exempt, so most people are exempt. For example, tutors, online tutors can only obtain an exemption through the referral agency category of exemptions, which comes with 11 requirements that have to be met, all 11 requirements. And most tutoring companies can't operate in the real world like that. In other words, they wouldn't be allowed to provide curriculum or training or branding or anything like that. They'd have to be just like a Craigslist posting. So virtually, tutors are, a lot of them, just out of luck. And the same holds true for many other professions that have partial exemptions that come with restrictions. We saw all of these headlines about musicians are all exempt. Well, no, they're not. Only a segment of musicians are exempt. And even those bands, those local bands that got an exemption, their exemption comes with a restriction in that they cannot perform any more than once a week at the same venue. Otherwise, they would have to make all of their band members employees, or the venue would have to hire them as an employee. So think about that for a minute. Once a week, you could play 4 Saturdays a month at the brew pub, but you couldn't play a Friday and Saturday consecutive gig once a month, because that's how the law is worded. Churches are in the same predicament with, you could have a guitar player or an organ player playing as an independent contractor once a week on Sundays, but when Christmas rolls around and you have a Christmas production and you have rehearsals and you have other days, that church would be required to make all of their musicians employees for the entirety of the year permanently, even if they only come out to play once a week, just because of that one caveat. So it's all there's a lot of smoke and mirrors in the exemptions, and a lot of people have partial exemptions.
And that doesn't make sense either, because the whole spirit of the law is like, you can't have an architecture firm having independent architects as contractors, but a church is not a musical organization. I mean, it doesn't make sense.
You're
Well-
part of religious services is what they'll say, same line of business.
No, it's musical or theater. There's a whole, if you read the law, there's just hundreds and hundreds of words pertaining to performing arts and musical theater production. If you're a musician that wants to play at a local playhouse, just a community playhouse or a children's theater, you cannot be an independent contractor. They have to hire you as an employee. That's why it's very well documented in California that community theaters and small and regional theaters have just been hammered by AB5. The concert dance community in Los Angeles is completely destroyed by AB5 because these small production companies, who are a lot of them run by women or single people or even minorities, they cannot afford to make every single person, even a one-off for one day, put them on payroll. It increases the cost of a single production by 40 to 50%. They just can't do it. So you can read articles about this, and even in the Los Angeles Times and the San Francisco Chronicle have documented over and over and over the destruction that AB5 has caused that sector alone.
What are we going to do about the election? We've got primaries coming up for the Senate seat. So far, all the announced candidates are, ProAct supporters. What can and should we be doing as Californians on this?
It's unfortunately, if you read the Cal Matters article that came out today, all of those 3 candidates, Katie Porter, Adam Schiff, and somebody else,
Barbara Lee.
They're all kissing the ring of Lorena Gonzalez, the author of AB5, who is now the leader of California Limit Federation. So in order for them to get the kind of funding and backing that they need for the campaigns, which is in the millions and millions from unions, and also the free labor that they can have, because AB5 restricts campaign workers from being independent contractors. So an incumbent has all of these vast resources of boots on the ground from unions for free. But if you're a little grassroots candidate or, you know, you have to make these people, these door knockers and whatever, you have to put them on your payroll. So
Well,
that,
there's no incumbent for that election.
no,
So
and
they're
so,
all in the same boat essentially. And one of them is going to win because it's unlikely you'd have a Republican unless these other folks split the vote. It's possible, I suppose.
well, Katie Porter was Lorena Gonzalez's prom date to the State of the Union address in Washington, D.C. earlier this year. So she's already kissing up to Lorena Gonzalez. She's despised across, you know, I mean, does she not know that even Democrats who've been harmed by AB 5 actually really despise Lorena Gonzalez, you know, and that's what you'd
I
have to
remember something about that.
you
but-
have to kiss the ring of big labor in order to be a candidate.
Mark
And-
Kelly won even opposing labor.
In California, it's a little bit different.
So
From
Jamie, I know the federal level is different. Here in New Jersey, we have 2 Democrat senators as well. It is very hard to get them. One of them to this day will not even take a meeting with us. It's like Karen just said, that they get a lot of their campaign support from these unions. They can't win the elections without them. So it's a problem. But what I can say again, at both the state and federal levels, is that it has been a handful of powerful moderate Democrats who blocked it. They didn't want to be seen with us. They didn't want us putting selfies of our meetings with them online. They didn't want anyone to know we had even met with them, but they knew that what was happening was wrong and they fixed it behind the scenes. So my suggestion, as much as it may feel like banging your head against a wall, and believe me, I've got the bruises at this point all over my skull, but just keep trying. Get a staffer some staffer has an aunt who drives for Uber or something like that. There's some staffer in one of these offices who does some freelance writing or something like that. Get that person, get a meeting with a legislative director or a chief of staff, whoever you can get a Zoom meeting with, and explain that you understand that they have their constituency of union supporters that they need to protect, but they're supposed to be working for us all. And you are a voter too, and you'd like to know what they're going to do to protect your career. That's what we did. That worked both in New Jersey and at the federal level. And you got to lock on a lot of doors to find those 3 people who will help you. But the margins are so close in a lot of these state houses and in Congress that if you just get 3 or 4 or 5 of them to help you, you win. So you don't have to win everybody over. You just have to win enough to stop the bills from going through. In terms of stopping the regulatory stuff, I think Karen Anderson's suggestion of writing op-eds is great, because this is going to be a big, long, extended legal battle where it's going to be a nightmare that we will never be more exhausted than we have been at this point. But getting our voices out, that is something we can do. We all have the skills to do that as writers. And it costs a little bit of time to write an op-ed. These are 600-word things. They're not 6,000-word things. You don't have to interview anybody. So that is something else that you can do. And you can write op-eds in your papers in California and say, look, I need a choice at the ballot box who, to use your own language, will protect my womb and my wallet. Which one of you is it? Tell me, say it, write an op-ed. These are things you can do, and they do make a difference. When we got that one placed in the Washington Post, I mean, Steve Sweeney's head almost exploded in the New Jersey State House. It was the greatest thing ever, and the bill died. That was it. So you never know. Shining a light on what they're doing really makes them uncomfortable. Anybody who watched the hearing in Congress saw it in real time, where I testified that we go to all these public hearings. It's all these independent contractors saying, stop what you're doing. This is wrong. And then some union lawyer shows up and says, we need to change the laws. And there was a union lawyer sitting right next to me. And I said, it's people like the woman sitting right next to me. Immediately, there was a congressperson from the Democrats brought out to say, no, we're fighting for everyone, not just for unions. It's a sore spot for them. So hit them again, hit them in that sore spot and say, you need to be working for us all. That's it. That's all we're looking for here. You're paid to work for us all, not just to work for the unions. Work for us.
I think the angle that I will take is we have 3 announced candidates for the Senate next year. None of them are out to protect my rights as an independent contractor. And then maybe Karen's got stats on how many ICs there are in California, and I'll
We just
write
posted
that
it.
up. I'll
There's a
write
new-
that, you know what, out of that.
There's a new story today. We just posted it in the Fight for Freelancers USA group with that data. You can pull it right out of there. It's right at the top of the Facebook page right
Tag
now.
me if you wouldn't mind.
Yeah, I will.
You know, Adam Schiff, I remember during the pandemic wanted to, I think he supported the pandemic unemployment assistance, if I'm not mistaken, because his district is so close to a lot of, you know, performing artists and filmmaking and everything like that. So he had to pander a little bit to independent contractors.
Mhm.
But Katie Porter, I don't know. She, can we get meetings with these senators and talk to them about the destruction that has happened to so many people and why it is that they support AB5 still? Why are they dug in on it? Is it because they just can't let go of Uber and Lyft and trucking? It's really important to try to reach out as best you can. And writing an op-ed is a really good.
I've written 2 for the UT, so I have no problem pitching a 3rd.
And AB5, the dumpster fire of AB5 has really been sort of a firewall in some respects for it spreading, you know, even worse than it spread. You know, if you mentioned AB5 to Chuck Schumer, for example, in that Zoom that we watched, Kim, remember that? They distanced themselves from AB5 and the ABC test. Even Julie Su, the Deputy Secretary of Labor, tries to distance herself from AB5 because she knows it's a disaster.
We hear it behind the scenes all the time. When we get into meetings with the aides to Democratic lawmakers, including at the federal level, they'll tell you flat out behind the scenes, nobody wants to go anywhere near this thing with a 10-foot pole. It was a nightmare. It was horrible. Then they all go on camera and support it because it's as our lawmakers explained to us in New Jersey, it is the #1 request of the AFL-CIO that these freelance busting laws go through. So these politicians have a problem. They have an actual problem where they need to win their campaigns. They know that this is wrong. So we're trying to figure out a way to just, none of us, believe me, Karen can tell you, having just come back from Congress, none of you want the swamp grass in your underwear. It's horrible to deal with the politics of any of this. But if you can just get a couple of the moderate Democrats behind the scenes to be your champions, we have, and we will continue to work on solving these problems this way.
And also educate yourself, and you can come to me and ask me questions because I've just had a front row seat to this since 2019.
Oh, I will.
They're going to say, well, licensed professionals have an exemption. It's not true. There's a licensed pharmacist in my group with a doctorate degree who had a longtime freelance career inspecting compounding pharmacies up and down the state. And she lost her career overnight and was blindsided by AB5 because pharmacists don't have an exemption. But a psychologist has an exemption. Why is that? Why does a proofreader have an exemption, but a transcriptionist does not? Why does an attorney have an exemption, but a paralegal does not? Why does a grant writer have an exemption, but a grant researcher does not? Why does a print journalist have an exemption, but a video journalist does not? Why does a doctor have an exemption, but a nurse practitioner does not? And it goes on and on and on and on. And
It's who has the best political representation. The lobbying is what does it. And that's a crappy way to write law.
Well, and for the record, there are 0 exemptions in the federal ProAct. There are 0 exemptions in what the US Labor Department is trying to do right now. There are 0 exemptions in what the National Labor Relations Board is doing. Writers, we're not going to get an exemption if this goes through at the federal level. We are not the trucking industry where 1 in 6 truckers on the road is an owner operator and it'll shut down the supply chain.
And
but
you
it's
saw that article about, why California's losing its port power. They didn't even mention that, but I'm sure that's part of the reason.
I can tell you out here at the Port of New York and New Jersey, where everything's been picking up, they're screaming their heads off. It's because of AB5. All the ships are coming around to this side of the country instead now. So
Right,
that's
and
happening.
another thing you'll face is this narrative that, oh, these are just innocuous. It's not going to affect legitimate independent contractors, this 6-factor test, you know? And it's just not true, because once this ABC test gets a foothold in federal law, it becomes like a spot of melanoma that begins to spread, because then it sets precedents for courts and legislatures to create laws and rulings that are anti-independent contractor. And so it's a very pernicious thing. And the narrative is always, oh, we're not going to harm you. But in reality, they'll say, oh, the ABC test isn't really in the FLSA 6-factor rule. But as Kim mentioned, if you read the 184 pages, which you would really, you'd be horrified, because you're reading it and going, this is going to put me out of business because of the chilling effect alone.
Well,
Oh, but wait, you're gonna get benefits.
Yeah.
Yes. Well, we saw how that worked out in California.
Mhm.
People that got hired to, as W-2 employees who were reluctantly became employees, got, part-time hires, rarely full-time jobs. And so where are the benefits in that? What's the difference between, there are no benefits.
One of the outlets that I used to do stuff for and can't anymore, what they have done is they have put a bunch of people as W-2 employees just on their payroll, but they don't work. And then this is radio, so now they're freelancers who have to provide free gear to this outlet, and they no longer have the ability to write it off as a business expense.
That's right. Intellectual
And they have
property.
no guarantee of any work. It's just like, well, we'll just put you on the payroll so that if like something comes up, then maybe, you could cover it,
Correct.
But yeah.
So
And then
the
my other
ProAct has the-
issue, this is sort of a sidebar issue, but I think that there needs to be like transparency so like on an ABC station, they'll say, oh, as part of this news story, we're just letting you know that they're also owned by Disney, and ABC is owned by Disney. I think there needs to be transparency in the reporting on this union stuff by reporters who are in unions.
Well, there are lots of narratives that we always are up against. One of them is that we're hysterical and making things up and we're getting bad advice from our attorneys. That's one. Another one is that they're equivalent to slavery and exploited. And, racism comes into play. And then
Russian
another,
bots.
right. And then another one that they put out there is that we're exploited and we just don't know it.
Or we're flacking for big business.
Right.
That's the one I see the most often.
I get called a paid opera to the Koch brothers probably once a month.
Oh, yeah. If you're,
I could
yeah.
use the check. I need a new furnace, but not true. To Susan's earlier point where she was talking about people being put on the payroll, but not actually being able to earn a living that way. I want to share a story that I shared in front of Congress. We, the 4 leaders of Fight for Freelancers, me, Debbie, Jen Singer, and Karen Warren, who I think many of you know from ASJA as well. We all did a phone call with, we requested a phone call with the primary sponsor of the federal ProAct in the United States Senate. We got on the phone with the top legislative aide. It's a woman who has since been promoted and is now in the US Department of Labor working on their independent contractor stuff. And Karen Warren explained to this aide that the previous year she had about 35 clients as a freelance writer, and that she didn't do anywhere near 40 hours a week of work. Like most of us, none of us are doing that kind of thing for anyone. So Karen explained to this aide that her best case scenario, if this freelance busting language gets into federal law and regulations, her best case scenario was that overnight she goes from being a freelance writer in control of her day and her 30 clients to being a person who now has 30 part-time bosses as a part-time employee of 30 different companies. And she said, how on earth can a human being function with how do you take a bathroom break, let alone schedule a sick day or anything else? How would that even possibly work? And the aide's response was, I have no problem with that outcome. So I want everyone to understand this is not an unintended consequence. They know what they're doing to us. This is intentional. That's why everybody has, they don't care. It has been decided that we are acceptable collateral damage and we are in a fight whether we like it or not. So it is important to raise your voices and try to stop this madness, because it's really
So
quite
they've got labor unions on their side, which is a powerful, political force for the Democratic Party. But there's also other groups that have a stake in this that don't want it to pass. So who are our best allies in opposition? Is it the Chamber of Commerce?
No.
Is it, I mentioned Associated Building Contractors and groups like, trade groups like that. Who's
Truckers.
making the most noise?
Truckers are making noise, the financial services industry, the financial advisors, I think it was 98%. They did a survey. They don't want to be turned into employees. Those are people with money who have the ability to fight.
International Franchise
Karen
Association.
Anderson, I'm trying to think, truckers, financial services people,
Franchise Association.
franchises are with us.
Chambers are not very effective or proactive. Business associations would be important.
Okay.
U.S. Small Business Administration Office of Advocacy came down on our side after a very heated hearing where we were quite vocal. That was good.
Interpreters and translators.
Yep, they're with us. About 75% of them are independent contractors.
Mhm.
So if I put together an op-ed, Karen, can you send me your email address?
Sure.
Where are you based?
Dana Point.
Where? Dana Point?
Yeah.
Because I would pitch this to the UT.
Union.
And so San Diego Union
San Diego?
Tribune.
Yes. They're
So
a little harder to get op-eds in. I've done op-eds.
I've written 2 op-eds for them already.
Oh, good. I just wrote op-eds recently about the Ninth Circuit decision on the Uber and Postmates case, where this three judge panel unanimously stated that AB 5 plausibly violates the Equal Protection Clause under the 14th Amendment, and that Lorena Gonzalez herself was the whole thing hinged on her animus, direct animus.
I remember that.
So I wrote an op-ed about that for the Times of San Diego and also the Coast News, because it's San Diego is ground zero for AB 5.
How
Yeah.
so?
Well, Lorena Gonzalez.
Because Lorena's here?
Yeah, and then Todd Gloria was also a co-signer on the bill, and he's now the mayor of San Diego. And then
Okay.
you have the very powerful city attorney who started going after, I think, Grubhub and other various app-based delivery. So San Diego is where all of this arose.
Mhm. A bunch of
Well,
attorneys general, wasn't it just today or yesterday?
Yeah.
They filed a response in that case where
They
the court,
did.
yeah, and they came out and said, it's ridiculous. If you're gonna say Lorena Gonzalez can't talk crap about Uber and then make a law to try to hurt them, well, then no lawmaker could ever talk ever. And we're all going, yeah, that's a bad argument. I don't know. But
this-
14, 15 attorneys general signed on to it from the blue states.
Well, it's not unusual, and I think that I was speaking to the plaintiff today about it. She was talking to her attorney, and so she fed me a lot of information from the attorney and how they're interpreting this move by the state of California. But the state of California could not defend AB 5 during oral arguments. I think it was January 13, 2022, and Kim and I watched it. at the Ninth Circuit, and the three panel judges were was a Clinton appointee, a Bush appointee, and a Trump appointee. So they're going to try to roll the dice again, the state of California, and see if they can get an on-bank, review of this again, or get the Ninth Circuit, maybe get different judges to try to look at it and say, and who's behind these amicus briefs? Vina Duval, Lorena Gonzalez. I mean, Lorena Gonzalez should be embarrassed by that ruling, because her name was mentioned 14 times. And they
She has
said
no shame.
the law was rooted in corruption, naked favoritism, and pure spite, and that she was engaging in backroom dealing. And that they also wrote that the Attorney General during oral arguments could not articulate a rational, conceivable defense about the arbitrary exemptions of AB 5. That is just a brutal indictment of the law. So they're going to do whatever they can to get it wiped out, and it may go, if they can't, then it goes back to the lower district court, Dolly Gee, and she's going to have to take into consideration what the Ninth Circuit said about, she was the one that originally dismissed the case outright in February 2020. And so she would basically, if she were to follow what the Ninth Circuit is telling her, she would have to declare AB 5 unconstitutional for Uber and Lyft.
So we've been talking for about an hour and a half, and I know people's eyes are probably glazing over at this point with all this stuff. Hopefully the point that we have all together gotten across to you today is there are powerful forces out there that want to take away the right to choose to be a freelance writer. That's what's happening. And we are trying to stop those forces. So we all try to stay on top of all this stuff. It's a lot to try to keep track of, and we all help each other from the different states. So if you want to come on over to one of our Facebook groups, Karen's is called Freelancers Against AB 5. Debbie and I are in Fight for Freelancers USA. You'll see us in each other's Facebook groups talking about things. I see Libby Slate saying she submitted a question. I don't see a question. Roberta, do you see a question?
I'm looking.
I'm sorry, Libby, I didn't see a question. Just repeat your question, please.
Hi, yeah, I submitted in where it says Q&A. Well, in other words, not in the chat part there, I just had erroneous plus marks. But my question is, at least I know in LA and California, so I'm assuming it's the same for some other at least cities and states, they have small business entities and they profess to be there to help small businesses and their owners and expand their business and offer resources and encourage them, all of that. And I was wondering if anyone had ever been in touch with them to address the disparity of, at least on a state level, indeed not protecting business owners, small business owners, by going after ICs, since so many are one and the same.
I've been in touch with Orange County Business Council, and they were completely useless throughout all of AB 5, and I don't know why. Chambers of Commerce, most of them. There was a group in Beverly Hills of 13 chambers of commerce that was asking the governor to suspend AB 5 during the pandemic. The Black Chamber of Commerce came out against AB 5. The Hispanic Chamber of Commerce came out against AB 5, and in support of Prop 22. So there are various entities, but Small Business Association I found has not been helpful. And especially the Chamber of Commerce, the California Chamber of Commerce is, they're in Sacramento, so they have to wheel and deal and stay neutral and stuff like that.
I would add to that, Libby, to answer your question also. I'm trying to remember the data from the US Small Business Administration. I think it was 82% of small businesses in this country are non-employer firms, which means you don't have any employees. But that is not what people think of when they think of a small business. And it's not what a lot of lawmakers think of when they think of a small business. So part of the challenge that we have is the way our opponents are framing us as exploited, misclassified, downtrodden, confused, whatever, all that stuff. No one really looks at people like freelance writers who might be raking in 6 figures a year and working their tail off, and legitimate, you know, LLCs, some S corps, whatever. No one really looks at us and thinks small business.
Yeah.
That's one of the big challenges, that we are the smallest of small businesses. So part of it is just educating people that, hey, we're not who these folks are telling you that we are. We're actually doing okay. We're fine. We got data and studies to back it up.
And by the way, speaking of LLCs and S corps, having an LLC does not exempt anybody from AB5, because AB5 didn't change the corporations code. Having an S corp won't exempt you either solely. I mean, it's part of a 13-prong business to business exemption, but having an LLC won't save you. So in the early days of AB5, we had some shady attorneys come swooping into my group and try to sell services about, oh, you need an LLC, come, you know, and in California, it's $800 a year plus, you know, more fees. And when all is said and done, you can be a sole proprietor and still be eligible for that business to business exemption. So why go to the extent of getting an LLC? You can also, it doesn't protect the hiring entity from getting audited if their LLC client turns out to be quote unquote misclassified. So
We asked flat out in New Jersey, what if we do S corps? What if we become S corps? Would that satisfy Part C that says you have to be engaged in the customary business, whatever the language is, you got to be in business? And they said, no, there's absolutely no language in these tests that says, you know, if you do these 3 things, you're in the clear. They're intentionally being written in ways that they can be manipulated. The goal, the goal is they want us all reclassified. They don't want independent contractors to be able to earn money.
right,
So-
and that C prong is a very problematic. The B prong gets all the headlines, but the C prong, think about it. You have to be customarily engaged. So how are you able to launch your career and get your first client?
I couldn't have signed a contract to write a story for a magazine starting out if this had been the law back then. Wouldn't have been legal. Because the client would have looked at me and said, are you customarily engaged in business with other people? And I would have said, no, this is the first freelance article I've ever sold. And they would have said, well, that's too big of a legal risk. We don't want to face the fines. We don't want to work with you.
Yeah, and what if you're going to be helping helping a running event, a 5K, for example, doing, you know, handing out bib numbers, for example, and they pay you as an independent contractor for just that one day. Are you customarily engaged in that occupation? No, so you don't pass the C test. There's so many landmines in the ABC test that it's absolutely unbelievable. That's why
Another one to watch out for in this 6-factor thing that the US Labor Department's trying to do. If you're a freelance writer and you have regular clients, maybe you write a column every month for somebody or something like that, which a lot of us do. We have anchor clients who come back to us month after month. We love them. They're great. One of the factors in the US Labor Department test, I don't have it right in front of me, but it's if you have a contract or a relationship that's routinely being renewed, you are most likely going to have to become an employee. So
Right,
how
how
can you be a freelance writer with a monthly column in a magazine and pass that test? It's not, they're writing the tests so that we can't pass them. They're not legitimate tests is what's
And
happening.
another thing, photographers are supposed to be exempt. Susan, I think you'll be interested in hearing that wedding photographers are coming into my group in recent days and telling me that they're getting audited by the EDD for bringing on a second shooter to a wedding, even though that second shooter has their own equipment and is doing their own thing at the wedding. And the auditors are telling them, even though you have an exemption, if you tell the second shooter where to show up and what time, that's considered control and direction. And that's the A prong of the ABC test. So when you watch these webinars with EDD and they talk about independent contracting, they just say, you know, they focus on that control and direction, and they can create it out of thin air, even for people that are exempt. We've got the dog walking services coming into our group and they have a specific exemption in the referral agency category, yet they're being audited.
So if you're doing freelance editing, I know we have a lot of people in ASJA who do freelance editing. Think about how people who want to misclassify us would interpret, are you under the control of the hiring entity? What if somebody gives you a style book and says, I want you to edit the book in keeping with this style book? Could they call that control and say you're no longer a freelancer? Yes, they can. This is who they are. They can do anything they want the way these things are being written.
That's right. And in AB 5 in the writer's exemption, it says, you know, she removed the cap, but then she added a new caveat that said that the hiring entity cannot hire you to replace an employee doing the same work at the same volume. How, as a hiring entity, can you prove that you aren't doing that, especially after the pandemic wiped out so many W-2 employees, you know, from payroll to begin with? So how can they revive their freelance staff without violating that caveat? So it's something that if you're risk averse, you're especially if your labor law attorney is risk averse, they would advise you to stay away from independent contractors because of that caveat alone. So a lot of the exemptions have smoke and mirrors in them. And this whole narrative that, oh, you have an exemption, what are you worried about, is not panning out in real life here in California.
Ladies, you are amazing. I think you probably exhausted as well. So I think we will let you go and enjoy your evening. And thank you. We have learned a lot, a tremendous amount. And I think those who are on this Zoom have a very great reason to give you a round of applause and to thank you for your hard work.
May I say one last thing?
Sure.
I have been a member of Karen's group, I guess, just about since she started it, and I considered that I was pretty much up on things because of that, and reading all the prodigious information she posts regularly. So thank you for that, Karen. And I learned a lot today, and I already knew a lot, and I still learned a lot. So thank you all.
Thank you for saying that. Well, we live it and breathe it every day. It comes across our page and Twitter and everything else. And it's so convoluted that it's really hard to explain it in less than 15 minutes. People don't get it. It's a very confusing thing. And a lot of freelance influencers on Twitter and Instagram, they're just completely clueless about the attacks coming their way against independent contracting. They just keep, you know, posting, here's how you can make this amount of money, and here's how you pitch, and this, that, the other. And you're like, hello, wake up. They're coming after us on the national level. They really are. They did it to us in California. It can happen on a national level.
Yep.
Thank you very, very much. And
You ladies managed to get any other work done with all of this work. That's impressive.
You know what it is, Roberta? I don't know about anybody else. I make 100% of my income as a freelancer. I do freelance writing and editing for 20 years. When they come for 100% of your income, it's not a choice at this point. Like, either you fight or you lose everything. So I don't know. I am a 50-year-old. I'm 50 for another couple days. I'll be 51 on Sunday, but I'm 50 right now, and I'm tired, and I don't want to have to start a whole new career at this point. And so the choice is either we fight this off or we're kind of hosed. So it happened to come to our states first. It is now coming for everyone. We know it sounds crazy, but here we are. We're telling you this is what's happening, and we have figured out how to beat it, and we need everybody to help. That's the message.
Thank you.
so much, and you're powerful speakers as well as writers, and we do appreciate it.
Thank you. It's nice to hear. Thank you.
Very much. Very
Thank you so much.
I'm going to stop recording now.